My name is Jocelyn Kennedy. I'm the Executive Director here at the Harvard Law School Library. It's my pleasure to welcome you all to today's books talk. I also want to thank the Dean's Office for co-sponsoring, providing the lunch. Please keep eating. If there's more food, get up as the day progresses. Today's book, When Should Law Forgive?, explores whether, when, and how forgiveness is extended under the law. Today's author, Martha Minow, is the 300th anniversary university professor at Harvard University. She teaches and writes in areas of civil procedure, constitutional law, family law, international criminal justice, jurisprudence, law and education, nonprofit organizations, and public law, among other things. She's an expert in human rights and advocacy for members of racial and religious minorities and for women, children, and persons with disabilities. She also writes and teaches about privatization, military justice, and ethnic and religious conflict. She's authored many books and articles in law, philosophy, and history. Professor Minow is the vice chair of the Legal Services Corporation, the bipartisan government-sponsored organization that provides civil legal assistance to low-income Americans. She has served on the Center for Strategic and International Studies Commission on Countering Violent Extremism and on the Independent International Commission of Kosovo. She helped to launch Imagine Coexistence, a program of the UN High Commissioner for Refugees to promote peaceful development in post-conflict societies. Her 5-year partnership with the Federal Department of Education and the Center for Applied Special Technology worked to increase access to the curriculum for students with disabilities and resulted in both legislative initiatives and a voluntary national standard opening access to curricular materials for individuals with disabilities. Professor Minow served as Dean of the Harvard Law School between 2009 and 2017 as the inaugural Morgan and Helen Chu Dean and Professor. As Dean, she strengthened public interest in clinical programs, diversity among faculty, staff, and students, interdisciplinary studies, and financial stability for the school. She clerked for Judge David Balzon of the United States Court of Appeals for the DC Circuit, and then for Justice Thurgood Marshall of the Supreme Court of the United States. Joining us today as commentators, Homi K. Bhabha, the Anne F. Rothenberg Professor of the Humanities at the Department of English and Director of the Mahindra Humanities Center and the Senior Advisor on the Humanities to the President and Provost of the University. Toby Merrill is a lecturer of law here at Harvard Law School. Carol Steiker, see they're not in order. Carol Steiker is the Henry J. Friendly Professor of Law and Faculty Co-Director of the Criminal Justice Policy Program here at the Law School. And Delia Umanan is a Clinical Professor of Law and Faculty Deputy Director of the Criminal Justice Institute at Harvard Law School. Copies of today's book are available at the back of the room, and I think Professor Minow will sign them for you at the end of our talk. Professor Minow is going to talk for a little bit, and then we're going to turn it over to our commentators and leave some time at the end for questions. Thank you.
Thank you, Jocelyn, and you did some research, my goodness. Thank you all for being here. It's a tremendous honor to have your presence and your involvement, and this panel in particular. I'm just so moved by your willingness to look at this book and to engage in conversation with me. I wrote this book, When Should Law Forgive?, largely because for the last 20 years, people ask me, why did I write another book? So I wrote a book 20 years ago called Between Vengeance and Forgiveness, in which I examined legal responses and institutional, societal, artistic responses to mass atrocity and genocide. And I understood the project in country after country trying to find an alternative to vengeance, but also an alternative to forgiveness, because I don't know about you, but it's very hard to forgive horrific things. But ever since, and I've talked with people in many parts of the world about this, people have said to me, why are you looking for an alternative to forgiveness? Isn't forgiveness something we should be looking for? So that's what I've been grappling with, and became very interested in two kinds of ways that law itself can forgive. One is that law, legal institutions, courts, new legal institutions like truth commissions can set up structures that can encourage people individually to consider apologizing and forgiving. Some forms of restorative justice take that pattern. But secondly, which is more of a focus for the book, law itself can let go of justified resentment and grievance, which is my definition of forgiveness, letting go of justified grievance. There are instances in legal systems that are quite explicit, giving discretion or even mandating the letting go of justified grievance. In the United States, for example, the bankruptcy law, the Constitution guarantees that Congress has the authority to create a national bankruptcy law, which allows people to say, yeah, I'm indebted and I can't pay, and I would like to start over. Thomas Jefferson himself, a framer of the Constitution, was himself often in debt, and so he understood the devastating effects of it. But he also, being Thomas Jefferson, thought there was a political reason for this, that one generation should not bind the next with its debts. But on other places in the U.S. Constitution and in other legal systems explicitly provide for forgiveness. The pardon power given to the President of the United States and to executives is another example. There are less explicit forms of discretion that's granted, and it seems to me we are in great need of thinking about the rules for those forms of discretion so that they're not handled and distributed in unfair ways, in racially discriminatory ways, other forms of discrimination. And at the same time, I guess my overall concern is we are living in an age of resentment. We're living in an age of justified resentments. But if we all continue down our roads with our justified resentments, then we will have vengeance, and we will have the opposite of justice. So that's the reason for the book. I'm really eager to hear what other people think about it. I'm still struggling with the issues in the book.
Thank you all for inviting me. I am the victim of my son's great esteem of the Harvard Law School. He was a student here, and he said, "Dad, you know, your written texts might work well in the humanities areas, but here you just have to go there and speak it." Then I come here to find that my cherished friends have all written these wonderful bits of prose, and I don't have one. So I'll deal with my son later on, but let's deal with the book now. I like this book a great deal because it's a balanced, but it's a taut book. It's a tense book. It's a book that deals with ambivalence. It's not simply a book that has a kind of soppy empathy or sympathy, or it's a very tightly and interestingly constructed book. Talking about construction and form is my job. And so you have this notion of reconstructive justice, which is not so much about ends, but it's about the whole process through which ideas of right, wrong, justice, forgiveness begin to come. So reconstructive justice is a kind of, as Martha puts it, the creation of interconnections, concentric circles, I'm using her terms, convergences, to look at the larger patterns, or the larger, as she calls it, to widen our lens about justice, about forgiveness, and about coexistence. So this widening the lens is part of the vision of reconstructive justice, but widening the lens also has a mirror image in this book itself, widening the lens on wrongdoing. Martha opens up the question of wrongdoing. She suggests that wrongdoing is also part of a contextual, historical, cultural, class-based, gender-based network of issues, so that we can't simply point our finger at the wrongdoer without widening the lens. So there are two forms of widening the lens that go on here. And then the book is aimed at what Martha calls repeatedly wiping the slate clean. And wiping the slate is where I have some problems. Because, you know, even as much as you try and wipe clean the lens, there is always some shadow. There is always some lint, something there. And I want to know more about wiping the slate clean, particularly when wiping the slate clean has a marked futuristic drive in this argument. We're doing this, we believe in forgiveness of various kinds, but we do this because we want to be able to construct the future. Very important point. But it does bring an issue to my mind, an issue which is captured in the most common adage, forgive and forget. And I'm interested to know what that means in this context, because what I call the taut and interesting construction of the argument says that actually you can forgive and the law can take its course. You can, if we actually forget, then we are in that position where we keep saying never again, and it happens again and again. So we have to both remember and forgive at the same time. And it's this complex issue, whether it's to do with slavery, whether it's to do with race, whether it's to do with sexual harassment, and I think this is a very crucial argument now at the moment with the whole Me Too movement too, as well as other roads must fall in other parts of the country, in South Africa where I was recently, the whole decolonizing issue. So what kind of memory do we need to mobilize to make forgiveness productive without denying the fact that traumatic experiences cannot simply be wiped out either by legal forgiveness or the ethics of forgiveness? We groups, individuals who are actually traumatized by violence, by denigration, by racism, that wounding, that anxiety keeps returning. And in a way, as Freud put it, anxiety returns to protect you from a trauma. So I want to know more about this idea of being able to forgive and not to forget. And I think this is a very important issue because it deals with something, Martha, that I think you haven't, in my view, you've not decided to spend time on, which is the whole question of memory. And I think the law has its particular forms of memory, codified memory, but the groups that are involved in this process of forgiving have other kinds of memory. And I think those memories, the legal memory might be more codified, the existential memory of experience might be more affective. It is something that cannot be controlled in the same way. So wiping the slate clean, but how do you do it if you are caught in these different forms of memory and shock and terror and the trauma that will, over time, relax its grip but refuses to go away in the act of forgiveness? So how do you deal and how do you keep these two things? And that's why I like the book, because it is a book of ambivalences. It's a book of tensions and torsions in an argument. This brings me then to the point that follows, which is one way of doing this is to take what Martha calls, I think I'm quoting, taking the perspective of another. So by taking the perspective of another, you can try to some extent, both in the legal and in the interpersonal, you can try to wipe the slate clean. Now, there is, of course, another great thinker who took Eichmann to task for not being able, as she put it, and of course it's Hannah Arendt, not being able to ever take the standpoint of another. Very controversial, happy to talk about it, but when people kept saying his guilt is for what he did, she said his guilt is also for what he thought and what he could never do. He could never put himself in the position of another. But Arendt's argument is an ontological argument. It's an argument about being and the way in which being through language always demands what she calls a sense of alterity. When you confront within yourself that who you are not, that sets you on a moral and ontological grounds. But here, we're not talking so much about alterity and ontology, we're talking about intention. Somebody, in a blur or in a premeditated way, did you some harm. There is a kind of intentionality without which, of course, the law would find it very difficult to intervene. So how do we take on, in the act of forgiveness, of an intended act, how do I take on the perspective of another? How do I, to forgive, introject even when I reject the perspective of a rapist? What do I do? How do I identify myself with that? Do I justify it on the basis of background issues and upbringing and violence? What is it that I need to identify with in acts that I find entirely reprehensible, acts that I do not want history to forget, and acts that I do not want to forget, and I do not think groups should forget, but they should negotiate them. So I'm interested in what is it that I identify with in the act of wiping the slate clean, or institutions. What is it that they identify with in trying to construct an ethic and a politics of forgiveness? And my final point really is about the place of narrative. And I know, Martha, that you're very interested in the question of narrative, but again, in this book, that's not been your particular brief. But narrative, particularly in acts of forgetting, is often thought about as listening to the story of the victim and listening also to the story of the oppressor of one kind or the wrongdoer. That's the way you negotiate. That's the way they did it in Rwanda, in the Gacaca courts. That's the way they've done it in many other places. But too much emphasis, I often think, is given on who is the narrator, crucial though that is, and less upon what is a narrative. Because I think when you think about a narrative as a collective act of the generosity of the imagination to incorporate even those elements of alterity or otherness that you find strange at first. It's when you take in the historical contradictions. Narrative is about trying to negotiate things that are incommensurable, things that are asymmetrical. So as much as we talk about, very often, I've just come from a conference last week in New York, in London, which was set up around the whole question of refugee narratives. And the emphasis was considerably on who narrates and how important it is to give that expressive right for people to narrate. My point was, you can keep talking about the who, but if you don't talk about how the narrative is constructed, not merely its content, but its entire discourse, just as when you read a legal argument, you look at the whole construction of the judgment. If we don't do that, then in a way it's very difficult simply to think about narrative as a kind of one-on-one intersubjective relationship, creating the grounds for forgiveness. I think we have to think about narrative as a collective, imaginative act in the jumble of its causations and the jumble of its expressive forms. Narrative doesn't come to past, present, and future. And I raise the question of narrative here, Martha, because I think that there is a certain linearity about the future in the argument. And going back to where I started, I really think that the problem in who do I forgive, how do I forgive, how do I wipe the slate clean, is partly the problem of time as much as it's the problem of anything else. The way in which different modes of time, traumatic time, will not lie quiet when actually the legal process is very forgiving. So it's those sorts of contradictions, those sorts of interesting challenges that concern me today. And I apologize again for not having a more polished paper to give. Thank you very much.
That's wonderful. Thank you.
I told Homi his superpower is speaking without notes. That's extraordinary. Thank you, Homi, for those wonderful remarks. I'm going to rely a little bit on my own notes here. My own superpowers. I am delighted to be part of this terrific panel to celebrate and discuss Martha Minow's groundbreaking book, When Should Law Forgive? Thank you, Martha, for writing this book, and thank you all for being here. I want to start with a serendipitous story. As I was reading this book, the MacArthur Foundation, on whose board I should add Martha has sat for many years, announced this year's winners of its Genius Grants. Among them is a woman named Sujatha Baliga, a lawyer known for her innovative work on restorative justice. In one of the many interviews that followed the announcement of her award, Baliga explains how she came to her work. As a child growing up in Pennsylvania, Baliga was sexually abused by her father over the course of many years. This experience led her to want to become a prosecutor and to lock up child molesters. On a post-college, pre-law school trip to India, she traveled to Dharamsala, home to the residence of the Dalai Lama, where you can actually leave messages asking for the Dalai Lama's advice at the gatehouse of his residence. Baliga left a message that read, quote, "Anger is killing me, but it motivates my work. How do you work on behalf of oppressed and abused people without anger as a motivating force?" In response to her question, the Dalai Lama invited Baliga to a private audience at which he gave her two pieces of advice. One, to meditate, and two, to forgive and open her heart to and align herself with her enemies. Baliga reports that she laughed out loud, exclaiming, "Open my heart? Align myself? No way! I'm going to law school to lock those guys up." She says the Dalai Lama patted her on the knee and said, "Okay, then just meditate." So Baliga did take up meditation, and she describes having an extraordinary, spontaneous experience during meditation that, to her surprise, led her to forgive her father. She describes the experience as a sudden and complete, quote, "relinquishment of anger, hatred, and the desire for retribution and revenge," end quote. This experience led Baliga to embrace and advocate for restorative rather than retributive responses to criminal offending. What does Sujatha Baliga's story have to do with Martha's book, you may well ask? When Should Law Forgive is an intellectual form of the meditation that led Baliga to have her epiphany. Reading it is an experience that I predict will lead forgiveness skeptics to have a parallel epiphany and to see new, good reasons to embrace law's forgiveness in contexts in which they may have previously rejected its application. One especially compelling way in which the book engenders such epiphany is by considering forgiveness in an extremely capacious way, linking contexts that no one has compared before. Particularly powerful is the book's treatment of forgiveness of debt in the context of individuals and businesses, as well as governments, both local and national. In these contexts, it may be easier for some to see how the wrong of debtors not paying their lawful obligations should be contextualized so as to take account of the contributory wrongdoing of creditors and also of the positive individual and collective effects of the possibility of a clean slate or a fresh start for debtors. These insights offer skeptics a way of thinking about forgiveness in contexts in which they may be more prone to accept it, which they then may be able to apply to contexts in which they are more likely to intuitively resist it, such as forgiveness for child soldiers who have committed atrocities during wartime, and amnesty and pardon for other serious criminal wrongdoers. In my own work, as a scholarly proponent of what I call legal mercy in the context of criminal justice, I have had to myself grapple with non-frivolous grounds for skepticism about forgiveness and mercy. And I discovered in my research someone who really posed the problem of forgiveness and mercy really evocatively. And this person, amazingly, was writing in the 11th century. This is Saint Anselm of Canterbury, who was posing the question of how God, who was supposed to be a God of perfect justice, could at the same time also be a God of perfect mercy. And so he wrote, "What justice is it that gives him who merits eternal death everlasting life, How then, gracious Lord, good to the wicked, can you save the wicked if this is not just and you do nothing that is not just? St. Anselm also raised, so I think that's like one central question, how can we say we're committed to justice if we don't give justice to wrongdoers? And St. Anselm also raised what I think is the second hard problem, which I call, he didn't, the equal protection problem of mercy. He writes, but if it can be comprehended in any way why you can will to save the wicked, yet by no consideration can we comprehend why, of those who are alike wicked, you save some through supreme goodness, and you condemn others through supreme justice. So St. Anselm goes on to develop a theological answer to these, what he calls these two paradoxes, but it relies on Christology and Jesus Christ's sacrifice. Obviously, in human terms, we have no extraordinary theological answer to what appear to be the paradoxes between justice and mercy and the worry of the equal protection problem, what Martha calls the fear of discrimination and unfairness in the application of the law's discretionary forgiveness and mercy. And I think what I love about Martha's book is that it grapples directly with these hard questions. For example, in the child soldier context, the book goes to great lengths to try to explicate why justice in response to wartime atrocities by child soldiers does not necessarily demand the use of the criminal process and the imposition of retributive punishment, but rather how justice might better be delivered through other types of processes, drawing from well-known processes such as juvenile justice, restorative justice, or truth and reconciliation models. And this, I think, speaks a little bit to Homi's question of how can we remember while we forgive. Martha wants to draw a distinction between holding responsible and punishing. And she wants these processes to recognize responsibility while at the same time foregoing punishment. And I think that is part of the answer, perhaps. Sorry to hop in there and before Martha could even get to it. But part of the answer to how do you remember and forgive. And in the clemency and pardon context, Martha explains, just to be clear, that not all pardons are created equal, and she explicitly rejects, for example, President Trump's pardon of Arizona Sheriff Joe Arpaio for continuing to engage in outrageously discriminatory police practices and flagrant violation of a federal court order. Martha concludes that the possibility of unfairness and abuse of the tools of legal forgiveness is not a reason to abandon them. Rather, she calls for what the law does best, the creation of procedural and substantive guideposts for using the pardon power, and more generally, for developing what she calls, quote, rigorous, reasoned analysis about when forgiveness is and is not warranted, end quote. So I conclude by saying When Should Law Forgive offers us all a running start on exactly that rigorous, reasoned analysis that Martha calls for to resolve these puzzling and difficult paradoxes of justice and mercy. I think St. Anselm, among many others, would be proud.
His eyes were dark, and he was close to tears. And he looked at me and said, "Will I be going to jail? And will I be going to jail for a very long time?" He was shaking. I looked over at his mom, and his mom was shaking. She was nervous. She was holding the hands of her 13-year-old boy. I found out that he was diagnosed with bipolar disorder, and that he had ADHD, and that 2 weeks prior to this conversation, he was sitting in his living room playing video games in his underwear when another individual went to the window, videotaped him sitting in his underwear playing video games, and proceeded to post it on Snapchat where 300 other kids saw it and began to make fun of this 13-year-old. This 13-year-old then went to school and realized that he was the butt of many jokes. And when he realized that, frustrated, angry, he lashed out and said, "I understand why the Parkland shooter did what he did." And for those comments, he was promptly hauled into the principal's office, handcuffed, and charged with making terroristic threats, and was facing arraignment when I received a call from his mother. And as I looked over the case, I said to myself, this is exactly what Martha's book talks about. This is a prime example where we shall nudge the courts and the decision makers to exercise forgiveness. Now, I want to start by thanking Martha for writing this incredibly amazing, remarkable book. I have to tell you that I have taken it in various spaces in the last 2 weeks: the car wash, the grocery store, court. I have spent every day in court the last week actually, and people see the title and they're like, oh boy, they have so many opinions about forgiveness. And I can tell you people who haven't spoken to me very recently, including prosecutors, have come up, and we've had very robust conversations about it. So thank you very much. The other thing that you may know is that Martha is an incredibly kind and compassionate and wonderful individual. So I am just honored to be on this panel with you. So I love this book for a variety of reasons. The first is that it is a conscious and deliberate attempt to really force us to think about the law differently and how we can use the law differently. The second is that it's a book about humans, and it's humane, and it recognizes the frailty of humanity and human actions. And that's one thing that I absolutely love, because laws without human beings or human beings being able to enact laws is pretty much useless. Personally, for me, this book has forced me to think about why I do the work I do. For the past 21 years, I've had the privilege and honor of representing people that the book talks about, so-called wrongdoers, right? People accused of various crimes, men, women, and children. And it's been my honor and privilege to do so for the past 21 years. Invariably, the people I get to represent are individuals who are people of color, people who are poor, people who have mental health issues, addiction issues, and then you layer that with homelessness and other societal ills, and you are looking at individuals, human beings, who are already primed to do wrong. The other thing that it's also forced me to do this book is to recalibrate and really rethink why it is that I fundamentally do this work. As a Christian, somebody who professes and hopefully practices my faith as a Christian, I am reminded of how important it is to forgive. It is the very foundation of what I do. I'll start with a quote from the Bible. Ephesians 4:34 tells us that we need to be kind and compassionate to one another, forgiving each other just as Christ God forgave us. And then I'm reminded of John 8:1 that says, and if you remember the story in the Bible where there was a woman by the well who was accused of adultery, and several people were trying to stone her. And the Bible says that Jesus looked around and said to them, "He who's without sin, cast the first stone." And guess what happened? Everybody laughed, and the woman was there and by herself. So obviously, people are with sin, and people, but for the grace of God, we will be the ones in need of forgiveness as well. And so the book does a fine job, and what I don't want to do is focus on the interpersonal need for forgiveness. I want to focus on Martha's premise, which is nudging courts and decision makers in the legal system to actually practice forgiveness. I do want to talk a little bit about the historical context in which we find ourselves. As Martha said, we live in an age of resentment. We live in an age where there is a clamor, quite frankly, for extreme sentencing and extreme punishment. That's sort of our default position when somebody has done wrong. But I do want to remind you that that ought not to be the case. It doesn't necessarily have to be the case. The US, for example, incarcerates 25% of the world's prison population, although we make up only 5% of the world's population. According to the 2018 report for the Bureau of Justice, BJC, nearly 2.2 million adults were held in American prisons and jails at the end of 2016. That means that for every 100,000 people residing in the United States, approximately 665 of them were behind bars. And if the US prison population were a city, it will be amongst the country's top 10 cities. More people are behind bars in America than are living in major cities such as Philadelphia or Dallas. And a vast majority of people in prison are there for nonviolent driving, drug, and property crimes. I also wanted to give you a couple more statistics so that you're able to put this idea of forgiveness in context. In Boston, Blacks in Boston have a net worth of $8. I want to repeat that. The net worth of an average Black person in Boston is $8. But for whites, it's $247,000. $247,000. So imagine then if you were a Black person in Boston caught up in the criminal justice system and you're a white person caught up in the same system. Imagine the inequities already baked into the system by the time you get to court. And so, mindful of that, I am very grateful for the work that Martha does in the book, because it is necessary, particularly her treatment of juveniles in the criminal justice system, where we recognize that children are fundamentally different from adults in the way they reason, in the way they appreciate risk, in the way they make decisions. And because of that, and because, well, the idea is children are also open and able to be rehabilitated in a way that adults may not be, they deserve forgiveness and fresh start. And that links me back to my earlier anecdote of the young men whom I represent. Obviously, if the law wanted to throw the book at him, they could, at age 13, charge him, convict him, and send him, and commit him actually till he's age 21. Or they could be nudged, as Martha suggests in the book, to really think creatively about how we rescue this young man who clearly is a victim of bullying, who actually did wrong technically and factually and legally, but to really think about the underpinnings and to figure out exactly why he got to where to the point where he felt he needed to make such statements. And the book encourages us to think about doing exactly that. In Massachusetts and in the work I do, we are grateful to have a very progressive prosecutor who has thought through these issues, Rachel Rollins, obviously not without controversy. But she has come up with at least some charges for which she has decided that her office will choose to show forgiveness. Whether it's larceny under $250, trespassing, disorderly conduct, possession of drugs, she has made that decision. We also know that in juvenile courts, a case called Umberto H. has talked about how to make sure that if a defense attorney raises the issue of dismissing charges prior to arraignment, that those charges, that the judge has the obligation and the discretion to hear such a case and actually dismiss the complaint prior to arraignment to protect a child from having a criminal record. As you may know, there are collateral consequences for when a person has a criminal record. It affects housing, it affects employment, it affects pretty much every aspect of their lives. And the book then urges us to really think about those collateral consequences and to seek alternatives that will lessen the impact of those consequences on a person's future, particularly since we know that the criminal justice system is as intentionally really targeted a certain demographic of poor people, generally people of color. And so I do commend the book because I really think it provides us a roadmap, a framework to really think through alternatives to punishment, to extreme punishment. I think it's quite frankly very disgraceful that in this country we will spend money incarcerating people before we spend money feeding them, housing them, providing medical attention to them. And we claim to be a civilized society. It really is unconscionable when you really think of it. And I think that Martha's job does a fantastic, masterful job of really nudging us to think creatively about how we can be less punitive in an equitable way. I want to end, because I would like to be able to have us leave some room for questions, by telling you about one of my favorite jokes. I have so many of them, but this ranks up there. So there was a jury that returned a verdict, and the verdict says, we find the defendant not guilty, and we urge him to return the mule. And the judge said, that's a crazy verdict, it's inconsistent, please take it back, go back and reconsider your verdict. And so the jurors came back and said, well, we find him not guilty and he can keep the mule. and so that is the collective recognizing that forgiveness is an important part of the legal system. Thank you.
Just want to echo my co-panelists and say what an honor it is to be here to discuss the work of my teacher and mentor. Her work has influenced my work. I run a clinical program here. It's called the Project on Predatory Student Lending. We represent people who've been ripped off by for-profit colleges. Last year, we canceled almost $1 billion in debt. And so I think that's, I believe that's the perspective that I'm going to bring to this conversation. And as with everything that I encounter in this building, I found this book to be a challenge. It was really hard because for me, there's this predicate question of whether in the debt context, forgiveness is the right inquiry, especially the debt context in which I work. And I guess just to put it another way, there's the question of whether there's a legitimate trespass. And of course, we can think of cases on both sides, but I wanted to hone in on two different examples that come up in the discussion of consumer debt. And one is about predatory subprime mortgages, and one is about the debt that finances attendance at for-profit colleges. And with subprime mortgages, as I'm sure folks know, the products were targeted in a predatory way, the terms were predatory, and yet people bought houses, and there was nothing predatory about the houses. Like, the houses were mostly fine. And in many cases, people did not get to continue living in those houses, but of course, that's a separate question. So in the for-profit college context, first of all, there's no money that goes into the hands of the students, and they don't receive anything of actual value. And so there's a real question of whether a debt, in fact, arises. And this isn't unique among the world of bad debt out there. There are many categories of debt where what you're looking at is essentially a seller finance transaction where people don't receive cash and they don't receive goods or services of value. And of course, they target the same communities that Delia represents. You know, these products are largely targeted to poor communities and communities of color. And this is in addition to and aside from other markers of predatory transactions that the book addresses, like high-pressure sales tactics. And so instead of asking when should obligations be forgiven rather than enforced, a different question to ask would be, when is the obligation invalid and the resulting debt therefore can't be forgiven and must be canceled? And of course, as I said, there's this whole class of debt in the student loan space that it seems to me that forgiveness is the wrong concept and it's not a word that we use in my practice. And there's just nothing of value that's been received. And so as Professor Warren taught me, there's just a handful of doctrines available to show why a debt is not enforceable and there's a complete defense to repayment. And more broadly, it seems like the law is able to cognize this problem on an individual basis. And so when we bring these claims to court or to the media on behalf of an individual person and say this person is blind and was enrolled in an online trucking school, people get it, right? People understand why that was an invalid transaction and that debt must be canceled. But when we represent 750,000 people who attended ITT Tech in the last 10 years of its operation, which we do, and we say, look, this school was systematically signing loan documents without people's permission or knowledge and delivering nothing of value and charging 4 times the amount of a community college and lying about the fact that it placed anyone in jobs. It seems like the same judges and journalists who have an easy time understanding on an individual basis why this is a context for cancellation have a really hard time seeing that. And we slide into the broader conversation about policy change and the eradication of student loan debt and free higher education. And so instead of the equal protection question, I think of it as the aggregation question. And I don't understand why as a group, people are seen to be asking for undue leniency when, as individuals, their claims are recognized as valid. And I don't think it's an evidentiary problem. So that is the question I brought for you.
Well, this is a wonderful and amazing set of questions, challenges, and too generous a set of congratulations on this book. I guess I had each of you in my head when I was writing this book, so this is a dream come true. I'm going to say just a word, but I do want there to be time for comments or questions here. So just starting with Toby's very important point, I think that forgiveness is letting go of rightful grievance. If there isn't a rightful grievance, we're not in forgiveness land. And many of the crucial cases that you're involved with are cases where there is not rightful grievance. We should not understand an obligation as one that should be paid when it was fraudulent to begin with. So, and I think we have category mistakes, and that we make all the time about that. So thank you for raising that, and I think it's really crucial. Having said that, I also find that there's just more of a wellspring of generosity in this country, particularly dealing with Delia's point about mass incarceration, structural racism. If you use the word forgiveness, than if you talk about justice. And so part of this effort of this book is blatantly a political effort. And it's to recognize that we might have a chance for some coalitions if we use this frame as opposed to if we use some frames that I might prefer. And I'll be candid about that. And in part, it's because I think some people, to go to one of Homi's points, can take the perspective of others in some circumstances, but not in other circumstances. But then it's to Carol's, reminder to us that people have wrestled with the question of the incompatibility of justice with forgiveness for many, many, many centuries. What does justice require? What does justice demand? I think that justice is bigger than punishment, that justice is bigger than putting all the blame on one, rather than seeing that there are contributory blame to be distributed among all, that justice requires recognizing human frailty, and justice also requires knowing when not to forgive. So that's what I'll say, and let's open it up. There's a mic right over here, and there's a mic back there. If people want to say something, ask a question, tell a joke.
Thank you very much, Dean Professor Minow. My name is Samantha Lakin. I'm a doctoral candidate at the Strasser Center for Holocaust and Genocide Studies at Clark University, focusing on Rwanda. I'm a graduate fellow here at the Program on Negotiation at Harvard Law School. I haven't read the book yet, for full disclosure, but I did want to ask about your consideration regarding extraordinary versus ordinary crime, and kind of along with that, looking at, as Delia and others mentioned, structural versus kind of situational factors. I also am teaching a course in a prison this semester on comparative genocide, and it's been a huge challenge, thinking about people who have clearly by the system been deemed as having done something wrong, and then looking back, as an educator in low-income schools, et cetera, what led to it, and their relationship to victimhood, to perpetrating, and to justice, what they define justice as, and then thinking about that in the case of extraordinary crime like child soldiers. So I'm wondering kind of what you make of the law's role in, is there a difference in cases of extraordinary and ordinary crime, and also cases of a clear structural underpinning of what's going on versus maybe some situational factors that are not long-term and structural, but are there in certain circumstances and not others? Thank you so much.
Hard questions, so I will think about them longer than I will now answer. What I guess I do think is Hannah Arendt was right in saying that there's some things that law cannot fit and that forgiveness cannot fit. And I just think that's true. Having said that, we have very limited tools for dealing with horrors. And for law to do nothing is also terrible, or for societies to do nothing. So that's a general comment, but I'll think about that for a long time.
Thank you so much for speaking, all of you. You provided really insightful comments that were really thought-provoking. And I have a question about, and maybe it's it's kind of similar, but the difference between this conversation in the international and domestic context, because I have heard a lot about forgiveness in the transitional justice context after mass atrocity with truth commissions and different restorative justice mechanisms that I haven't heard so much about, or that I'm not sure exist in the U.S. And so, again, I also haven't read the book yet, but I'm wondering what your thoughts were in having this book transcend both international and domestic contexts, and what the differences are there, and how this has been explored in the U.S. context, and what important considerations are for that.
I think it's not by accident that this book is filled with comparisons, because if there's any method that lawyers have, it's to compare things and to say which one is like the other, which one's not like the other. And I just think it's very helpful, not that they're the same always, but to see that child soldiers actually have a lot in common with juvenile offenders in the United States, even though they're very different. And it jars us, I think, to do those comparisons. That bankruptcy and the treatment of debt is really different than the treatment of crime, but actually there are ways in which there's some similarities. So that's my basic approach. You know, if we talk about the debt of Puerto Rico, is that anything like student debt? Well, yes and no. But I think we start to become clearer about what are our moral intuitions and what is justice under different circumstances. You know, one of the ways in which this book is international is that I do look historically. And, you know, you think about every civilization, every philosophy, every religion promotes forgiveness. And many have developed what I guess I can only call a reset button. So whether it's the Jubilee or other traditions of a mass amnesty, and particularly around crime and debt. And I think by having that kind of long historical view and comparative view, that it's my effort to say to the United States, maybe it's time for a reset.
Thank you. You talk in the book about when law can create the sort of structures and situations that can promote forgiveness and reconciliation, like the Truth and Reconciliation Commissions or those kinds of structures. And I'm wondering if you could speak to whether there's a role for the law in creating the conditions for the forgiveness of America's original sin, and if you could speak to where you see reparations fitting into this conversation.
Well, first I have to say, this is Rachel Keeler, who makes my work possible. So thank you, Rachel. Thank you, Rachel. You know, Brian Stevenson, whose book, Just Mercy, in many ways is an inspiration for my own book here, he said something that just, two things that I just think about all the time. One is no one should be reduced to their worst moment. And the other is that he can win a case in the Supreme Court, as he did with the life without parole case for juveniles. But he says we won't really have change until we change the narrative, which, again, is Homi's point. And the United States will not have real change until we deal with, yes, we deal with slavery, and we deal with the treatment of American Indians. These are the foundations of this country. They're throughout the Constitution. We will not have a justice until we deal with it.
We're at time. That was big. Lots of amazing and important things for all of us to think about. Thank you all so much for coming. Thank you, Dean Minow. Thank you all for presenting to us.